Good afternoon, and welcome to the 2021 PTAB Year in Review webinar. We are going to go over a few housekeeping items. Questions can be entered via the Q&A widget open on the left-hand side of your screen. We will address questions live at the end of the program, time permitting. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. Also, please just leave the program and come back in and see if that helps. The recorded version of this presentation will be available on Foley.com within the next few business days. You may download a copy of the presentation slides via the resource list widget on the right-hand side of your screen. Foley will apply for CLE credit after the program in all applicable states. To be eligible for CLE, you will need to be logged in into ON24 for the full duration and also answer one or more of the polling questions with a 5-digit course code to be announced during the program. If you did not supply your CLE information, licensure, state, and bar number upon registering, please email it to lfreimark@foley.com immediately following the program. Please note, those seeking Kansas, New York, and or New Jersey CLE credit are required to complete the attorney affirmation form in addition to answering the polling questions that will appear during the program. A copy of this form is also available via the resource list widget. Include the 5-digit course code on your completed form and email it to lfreimark@foley.com immediately following the program. Certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. And now I will turn it over to Mike Houston, IP litigation partner in the Chicago office.
All right, great. Thank you. Hello, everyone. Thank you for joining us today. I'm Mike Houston with Foley & Lardner, and I've got with me my colleague, George Beck. Together, we manage the firm's PTAB trial practice group. It's a very vibrant group with a lot of proceedings in front of the PTAB on various types of proceedings on various sides of those proceedings. And we really appreciate you joining us today. We hope to be able to provide you some of our thoughts and some of the important decisions that came out in the last 12 months or so, and as well as provide you a little bit of our insight based on our own practices and experiences at the PTAB to hopefully make it an interesting and worthwhile presentation for you. So thank you again for joining us. We really appreciate the opportunity to speak with you. You should be able to see here just a sort of an overview of the agenda. We've got 4 main topics we want to cover with you. There will be a few subtopics within those that of course, we'll cover at the appropriate time. As the announcement said, if you have questions during the presentation, you can type those into your Q&A screen. And in theory, we should be able to see those live. If not, we'll try to get to them at the end and cover those at the appropriate time. So with that, let's just jump right in. And we'll talk about this first topic, which has to do with the interplay between PTAB proceedings and contractual provisions, whether those be form selection clauses or something similar that attempt to limit the form in which disputes can be raised. We've had a couple of important decisions in that area this year, including one very recent one, and we thought it would be a nice place to jump in to talk about just, under what circumstances can petitioners even reach the PTAB, even get in front of them with a proceeding, as opposed to having to litigate those elsewhere. So this is kind of a gateway topic to get in front of the PTAB. So the first case I want to talk about, it's fairly recent. It's styled as In re Max Power Semiconductor. It involved parties, Max Power and Rome, Japan, that had a technology license agreement between them. And in that license agreement, they had an arbitration provision, which is fairly common, of course. And that arbitration provision really wasn't anything too nuanced about it. It was a typical arbitration provision that said the disputes, rising under the technology license agreement will be handled by arbitration. And just for everyone's reference, I did copy Section 294A here, or at least part of 294A, just to remind everyone that, there's a U.S. code that says, hey, a contract involving a patent can have an arbitration provision for dealing with patent validity, and Furthermore, such provisions shall be valid, irrevocable, and enforceable. And so, I think at the time the parties were anticipating that arbitration would cover their disputes. When a dispute did arise many years later under the license agreement over some new products that Rome was developing and whether or not they were covered, Max Power indicated its intent to invoke that arbitration provision and have the dispute decided that way. But instead, Rome took a different course of action. Rome submitted several IPRs, 4 IPRs, in front of the board that the board then instituted. And so we want to talk about kind of what happened subsequently in that case. The first thing that happened was that Max Power did try to raise the arbitration issue in its preliminary responses, patent owner preliminary responses, and tried to tell the board that they should not institute, that this should be handled via arbitration. What did the board say in response to that? I just pulled a few excerpts here that I think are kind of some of the key excerpts from the institution decisions. The board basically said, no, we're not going to do that. Even if there's some question about whether this dispute falls under what should be arbitrated, we, the board, can't find any statute, rule, or policy that would preclude us from acting on the petition. And, we can't find anything that says 294 sort of cabins our authority, limits our authority to institute and hear these IPR petitions in the proceedings. They further went on to point out that their mandate, meaning the board's mandate, does not include contract interpretation. So they pointed out that just as in the past we have not enforced forum selection clauses in contracts, we're also not going to wade into disputes involving arbitration clauses. And so we're simply not going to use that as a reason not to institute. And so they went ahead and instituted on those. Max Power, for their part, wasn't happy with that outcome. And so the next thing they did is they filed I guess the best way to style it is an interlocutory appeal / mandamus petition to the Federal Circuit to try to get relief that way. The Federal Circuit didn't like the appeal aspect, the direct appeal aspect, because they said that was appealing an institution decision. So they kind of got rid of that piece of the appeal very quickly. They wrote a little bit more on the mandamus side of things, and essentially the Federal Circuit kind of came out the same way as the PTAB. And I've pulled maybe 4 excerpts here from the decision that I just wanted to touch upon. So one thing the Federal Circuit said was that, hey, Max Power really hasn't shown that they need this relief right now. They can always raise it in their any challenges they want to raise after the final written decision. So let's let this all play out, and we'll deal with it during sort of the course of the regular appeal. They also said that, hey, even though you styled part of your appeal as a mandamus petition, you still haven't shown that what you're really trying to do is an end run around an institution decision. And we all know that institution decisions can't be appealed. And so really you're just trying to kind of shoehorn in a way to appeal the institution decisions by raising this arbitration issue. And then they went on to say that yes, 35 U.S.C. 294 says what it says, but it doesn't ever deprive the board of the authority to proceed with an inter-parties review. And it just doesn't task the agency with doing that. And so at the end of the day, the Federal Circuit, denied the mandamus petition. There was a dissent, but the majority upheld the board's decision to institute. They did include in a footnote a statement that Max Power remains free to ask the courts to enjoin Rome from proceeding with the IPRs. So they kind of put that in there as a bit of an aside. So what happened next? Max Power took them up on it. They latched onto that footnote, and they promptly filed a motion for an injunction with the district court in Northern District of California, which is where some other disputes were pending, namely the disputes about whether the parties' dispute was subject to being arbitrated. So it's kind of a question of arbitrability, if you will. And so with that pending there, they filed the injunction motion. And in this case, the district court did agree with Max Power. And the district court just kind of went through what we would see as a little bit more typical analysis of arbitration provisions. And the first thing the district court said is, well, yes, we have to decide whether this dispute is subject to being arbitrated, but that question is left to the arbitrator in the first instance. And so we're going to do that first before the court saying that the parties are going to do that first before they let the dispute proceed in any other forum. And, the district court just latched on to that language I cited from 294 that just said arbitration agreements are supposed to be enforceable. They're supposed to be enforceable. The PTAB wasn't willing to enforce it. The Federal Circuit on mandamus wasn't willing to enforce it, but the district court was willing to enforce the arbitration provision. The last comment that the court made, which I thought was a bit interesting, is it went out of its way to make it clear that its decision on the injunction motion was not directed to the PTAB specifically. The court said, I'm not enjoining the PTAB from doing anything, but what I am doing is I'm ordering the parties, specifically Rome, to seek a stay or dismissal of the PTAB proceedings until, in the first instance, the question of arbitrability is decided. And so the parties then did subsequently file papers with the PTAB that asked the PTAB to stay the proceedings while the arbitrability question is decided in the first instance. And when the PTAB issued its decision doing exactly that, they seemed to indicate that they would subsequently terminate the proceedings if it determined that arbitration was going to go forward. So that termination hasn't actually happened yet, but that seems to be the way it's headed, assuming the arbitrator decides that the patent validity dispute that's at the heart of the issue is one that is subject to the arbitration provision. So that's an outcome from Max Power in the context of an arbitration clause in a contract. Let's switch gears and talk about another case that came out in 2021 that involved a non-disclosure agreement, an NDA. In this case, the Canoe v. Samsung case, the parties had entered into an NDA that was, I would characterize it as a more or less standard NDA where the parties wanted to be able to disclose to each other confidential information and to be able to protect that information as confidential, protect it from disclosure. The NDA did say that any legal action proceeding arising out of or relating to the agreement must be instituted exclusively in a court of New York, in New York. The parties never did consummate the business relationship. They never did, enter into any kind of collaboration agreement. So the NDA just kind of sat there and carried on its provisions for its term. But when a dispute arose later, specifically Canoe felt like that Samsung was copying some of its confidential information and was infringing its patent, Canoe sort of followed, if you will, the provisions in the NDA, and they sued in the Southern District of New York for alleged infringement. Samsung turned around and filed IPR petitions. And in that case, the court denied the request for preliminary injunction to stop the IPRs. And that denial of preliminary injunction made it up to the Federal Circuit. The Federal Circuit didn't spend a lot of time in this case in their decision, but they made 2 points that I wanted to highlight here. In the first point, they're making a distinction. They went out of their way to make a distinction. They said, look, in a typical patent license agreement, whether the patents are valid, we can see where that will very much, or at least most likely, impact the rights of the parties under the agreement. So in other words, patent validity we can see being tied to a patent license agreement, and therefore the dispute resolution procedures that are in a patent license agreement may be expected to be engaged if there's a dispute about patent validity. But they said the same is not true here, which just involved sort of a run-of-the-mill NDA, which was simply to keep information confidential. And they said that whether or not a patent is valid or not valid really doesn't speak to the question of whether or not there's been a breach of the confidentiality provision. So they're essentially saying that the dispute over patent validity is not tied to the provisions of the NDA themselves, and therefore Canoe could not invoke the forum selection provision from the NDA in that context. Canoe did try one other argument, which was to say that, hey, look, one of our defenses to Samsung's claims of invalidity is to say that that Samsung took our confidential information, copied it, and so their products embody copying of our technology. And so that's going to be one of our defenses to the patent invalidity claim. And because of copying, we think that really, necessarily invokes the NDA, the fact that they took our confidential information. The Federal Circuit didn't buy that one either. They said that evidence of copying may be a factual basis that comes up in one or both disputes over the NDA and over infringement, but one doesn't really invoke the other. So this argument about copying is not going to suddenly bring the dispute within the confines of the NDA's form selection clause. So another case where the Federal Circuit was not willing to enforce a form selection clause that the parties had advanced as justifying stopping IPR proceedings. All right, with that, let me move on to the last case I want to talk about in this section, and this is a very recent one. It's actually a 2022 case, but since it's on topic and so recent, we thought we should talk about it. And this is the Mekong v. Surrepta case. And just by way of background, this case involved a mutual confidentiality agreement between the parties, so somewhat similar to an NDA, I would say. But in this case, there were a little bit more express terms in the agreement. It had a couple sections that are important to the discussion and the outcome of this case. In one section, the mutual confidentiality agreement, the MCA, had a provision that said there will be a covenant not to sue. And I think the term was for a year plus 20 days, something like that, that the parties just agreed that they wouldn't sue each other, and they expressly put in there that those challenges, that the covenant not to sue included validity challenges at the PTO. So in other words, nobody's going to file a validity challenge at the PTO during the term of this covenant not to sue. The MC also contained a form selection clause, and this really kicked in after the term of the covenant not to sue. So after the covenant not to sue period ended, then the form selection clause kicked in, and that form selection clause provided that, quote, potential actions, and it had potential actions capitalized, and it had a separate definition for that. So it said, for all potential actions arising under U.S. law relating to patent infringement or validity shall be filed in the District Court of Delaware. And it had a section that defined potential actions as including any patent or other intellectual property disputes between the parties filed with a court or administrative agency. And I emphasize that word filed there because it's something that was picked up on really at the District Court and at the Federal Circuit. It was past tense. So filed, it sort of implies that it's already been filed, and leaves a little bit of a question mark about what's really meant there, whereas you would think if it were sort of proceedings that would be contemplated, that it might not use the past tense there. So the first thing that happened is Surrepta first filed some IPRs. When a dispute arose between the parties, Surrepta filed IPRs at the PTAB challenging some Nippon patents. Nippon countered that by filing an action in Delaware alleging infringement, alleging breach of contract of the MCA, and as part of that action, they sought a preliminary injunction to stop the IPRs. Judge Stark decided that preliminary injunction motion, and he took what I would call kind of a holistic view of the contract, the parties' MCA. And he said, look, that first section, and here it's referred to as Section 6, really that's the section that has the covenant not to sue in it. He said that first section with the covenant not to sue expressly calls out that IPR petitions, PTAB proceedings, just will not be filed. You can't file them. And he's saying, so given that was so express and so clear in that section, he found it just not credible that the later form selection clause, which had a bit fuzzier wording in it, that should also be read to preclude IPR proceedings. He was kind of comparing different provisions of the contract as a whole and saying that, when you read them together, he just was not of the opinion that later form selection clause was really meant to cover IPR proceedings. And he also latched onto the fact that that forum selection clause had a lot of other provisions in it, which I won't go into here, but it had a lot of provisions in it really relating to specifically to litigation issues, venue clauses and things of that notion. And he said, look, that just further convinces me that that forum selection clause was directed to district court proceedings and not necessarily meant to be a preclusion of filing IPRs. The last reason he gave for denying the preliminary injunction was that that forum selection clause applied for 2 years. And so he said, listen, if I enforce that the way that the patent owner wants me to, then the petitioner never will have a chance to file their IPR petitions because they've had a complaint filed against them under the patents. And so basically the clock will run out and the 1-year time bar will kick in. And so, what would be the point of having a forum selection clause that precludes IPRs that expires after 2 years, since it will be sort of moot by that time anyway? So he denied the preliminary injunction, and this was then taken up to the Federal Circuit. And so I'll talk about that next, the Federal Circuit's decision on this. The Federal Circuit took, I would say, characterize it as a different view of the parties' NCA agreement. They really focused almost exclusively on the forum selection clause itself. So they, if I were to summarize, they sort of took the view of, we think we can answer the question just by looking at the one clause, and we don't really need to look at the rest of the contract to decide whether it impacts or changes things. They first started by noting that the covenant not to sue and the forum selection clause were to some extent mutually exclusive because they covered different time periods. First, it was the time period covering the covenant not to sue, and it was only after that expired that the forum selection clause kicked in. And so they said, there was no overlap, there couldn't be inconsistency between them because they covered different time periods. And they went on to note that definition of potential actions that I mentioned to everyone just a bit ago on one of the earlier slides. They said, look, it's defined to include disputes filed with an administrative agency, and that must necessarily include IPRs. They kind of brushed aside the notion that word filed was past tense. They just weren't willing to get hung up on that. And so listen, at the end of the day, they decided that the forum selection clause would apply. A couple interesting quotes in the decision. The Federal Circuit noted that parties are entitled to bargain away their rights to file IPR petitions, including through the use of forum selection clause. And they said, listen, the fact that Surrepta, under our ruling, now Surrepta is not going to really ever be able to file the IPRs on these particular patents because they've now had a complaint served on them accusing them of infringement of those patents. They basically kind of, shrugged their shoulders and said, that's too bad. It's something that Surrepta agreed to. And by the way, if the dispute hadn't percolated up as soon as it did, then that 2-year window might not have acted as a bar. In other words, if the dispute had arisen, say, 18 months into the forum selection term, then it might not apply in the same way. So they weren't willing to use that as a reason to not to let the IPRs go forward. And then finally, they just said that if we don't enforce the forum selection clause and don't grant the preliminary injunction, then we, the Federal Circuit, think that Mekong, the patent owner, will be deprived of its bargain for choice of forum. And they pointed out that under that scenario, they felt like Surrepta would get multiple bites at the invalidity apple. I think that kind of maybe brushes under the carpet a little bit the estoppel provisions that would come out of an IPR proceeding. But anyway, they didn't get into that level of detail. Okay, so those are the 3 cases I wanted to cover. Let me just cover a few takeaways from those to wrap up this particular topic. I think one of the most important takeaways that people should appreciate is that parties can bargain away their right to file IPRs and to pursue IPRs at the Patent Office. If you choose to do so in a binding contract, you can bargain away that right. And you can do that via an arbitration provision. You can do that via forum selection clauses. Presumably, there are lots of ways to do that via your contract. And so that's something to have on your radar screen. Some parties will want to bargain that away, and some parties may not want to bargain that away, but you need to know that that's at least a possible outcome. And whether or not you've done that is, as you might imagine, it's no big secret that that's going to be controlled by what the language of the contract actually says. And so in all cases, you're going to have to turn to the language of your contract, see exactly what it says, and decide whether or not it really does bar IPR filings. Two small takeaways we can also gather from that is that the PTAB does not appear to be the place to try to enforce any type of arbitration forum selection clause. Notwithstanding the fact that 35 U.S.C. 294 says arbitration provisions shall be enforceable, the PTAB is not going to be the one to enforce those, it would appear. And the Federal Circuit seems to have backed that up in saying that, yep, we're not going to force the PTAB to wade into those issues. So where are you going to get that relief? What we're seeing so far is we're seeing the relief that has been achieved for the parties that have managed it has come via preliminary injunction motions filed at the district court, in some cases having to go up to the Federal Circuit on that preliminary injunction outcome. But that seems to be the avenue by which a party may more effectively try to enforce a forum selection type clause and stop PTAB proceedings. Okay, well, that's what I wanted to cover on that topic. And so I will, barring any questions, which I don't see any in our Q&A box, so I will turn it over now to my colleague, George, to move us along to the next topic. Thank you.
Thanks, Mike. I'm going to first talk about the PTO's director review process. So as most of us are aware, when the Supreme Court ruled in the Arthrex case that there was a constitutional issue and corrected the Federal Circuit's prior opinion in terms of how to deal with that issue, the PTO acted very promptly to issue guidance and implement director review. So I'm going to touch on that procedure and briefly discuss how it how there's some interplay with the prior existing procedure for requesting rehearing by a panel and seeking rehearing essentially through the Presidential Opinion Panel or POP review. So the guidance came out, as I mentioned, very promptly after the decision in June, and the PTO provided helpfully on its website some guidance in terms of questions and answers of what's the procedure for parties to follow, and it's relatively straightforward. And in terms of timing and scope, it's similar to request for rehearing. So a party may set forth a basis for review of a decision. They have to comply with the existing word limits and do it within 30 days. The PTO has made it clear that it has the effect of staying the time for pursuing an appeal. So, for example, after a final written decision, you normally have 63 days to appeal. If there's a request for director review, that deadline won't be triggered until there's action by the director on that request. The scope of the review is broader than a request for rehearing, in that, prior requests for rehearing is kind of limited to issues that the panel misapprehended, overlooked. The director, consistent with the Arthrex decision, can address any issue of fact or law. One thing that's worth noting, the Patent Office has made it clear that it's sort of an either or. If for example, you get a denial a decision on a final written decision, you could pursue a request for panel rehearing, but if you do that, you can't then ask for director review. So I encourage folks, if they are looking at this procedure, to look through each of the question and answers that the Patent Office provided. In terms of where is this, what results have we seen? We've seen a fair number of requests, but to my knowledge, there's only been two requests for direct review granted, both last November. One involved a case where the panel was found to have overlooked treating specific claims individually in terms of their priority claim. So it was, essentially a misapprehension of law as found by the director, and resulted in a remand back to the panel. There was a second decision where it was a follow-up to a Federal Circuit case, indicating that the board had not properly considered secondary considerations of non-obviousness. So in my view, at least so far, it hasn't had a substantial impact. It seems to be an avenue to have addressed some errors of law by the panel, but as opposed to kind of an overarching policy issues. As I mentioned, there's sort of an interesting interplay with requests for rehearings, which, as most of us know, can be accompanied by a request for review by the Presidential Opinion Panel. At least under the current PTO guidelines, you can those two procedures coexist. It's of course possible the Patent Office may choose to limit that, but currently, at least, there's two options. If you're unsatisfied with a decision, on a final written decision, you can pursue either direct review or request for POP review. The POP review, the intent of that, I think, is a little different as a policy matter. It was intended to address the issues of exceptional importance, to provide more input to assist the office with its kind of case-by-case approach to providing guidance on policy issues. So the scope of the POP review has, kind of a different approach, and it involves additional members of the Patent Office. The POP panel includes the director, the commissioner for patents, as well as the chief administrative patent judge. So I guess the takeaway from these procedures is, if you have a case where you're dissatisfied with the result, you may have to consider the respective advantages and disadvantages and timing pursuing these different avenues of review. One kind of, since we're talking about a year in review, it should note that there really hasn't been a lot of activity as compared to prior years in terms of designation of opinions as either precedential or informative, like we had seen in prior years. In fact, through that POP review process, there was only one POP request granted in 2021, and that resulted in the recently designated precedential decision in Toshiba America. I'll just, since we're covering the developments of the Patent Office, I'll briefly discuss the case, but I don't see it as having a big impact on most practitioners. But in that matter, there was a filing of a petition, I think 4 days before the bar date, and apparently there was some challenge that the actual funds for the fee, which are required to establish the filing date, did not reach the Patent Office until after the bar date. And so the issue was whether the submission through wire transfer was sufficient. The panel initially found that it was not, but it was a split decision, and there was a dissent by one of the panel members, and the Presidential Opinion Panel granted review, issued a relatively detailed opinion discussing the requirements of the statute and found that the submission there was proper. But that was really the only designated opinion that we saw come through the process of last year. What, in my view, is maybe a little more interesting is the next topic that I'm going to discuss, which deals with the kind of the implementation of the board's prior decisions relating to discretionary denials when they're considering whether to institute.
Great. Thank you, George. At this time, we are going to go back to our poll question and give you our CLE code for today. The code is AGHWA. A is in apple, G is in golf, H is in hotel, W is in whiskey, A is in apple. Please fill in that box and hit submit, and we will get your CLE code for today. Going to hang for just 1 second before we turn it back over. One last time, that code is AGHWA. Thank you. And George, if you'd like to move to the next slide.
Thank you. So what I'm showing on the slide, it's slide number 19, I believe, is the statistics that were gathered by Unified Patents. I've given a link to the report, but it's very helpful, I think, because they collect the data and synthesize in a way that's sometimes a little easier to understand than what's available through the Patent Office, with respect particularly to the basis for denials of petitions. And as this slide illustrates, I think most of us are aware there's been a decrease in institutions starting roughly around 2007, end of 2017, and along with that, an increase in procedural denials. And what I want to talk about is sort of breaking those down in the two categories that are particular focus are denials, discretionary denials under Section 314, particularly where the Patent Office is developed based on its case-by-case approach of setting forth rules for when it should exercise its discretion to deny a petition, as well as denials under Section 325, which are more firmly rooted in the statute. This next slide is illustrating procedural denials under that first category of 314, which, as you can see, was a dramatically increased following 2018. And these can be broken down based on parallel petition denials under NHK Spring Fintiv, and other, which is a much smaller category. For other, I can mention one grouping is where there's an issue of indefiniteness which might spring up, and we've seen a very limited number of cases where, particularly if the district court found claim terms indefinite, that it led to the panel deciding that would be just an issue that couldn't be adequately addressed in the context of an IPR. But the real hot topic is that continues to confront practitioners is looking at timing relative to parallel proceedings based on Fintiv. So as I think most of us are aware, Fintiv provides for what the board quotes frequently is the holistic approach that weighs 6 factors that were set forth in the Fintiv order. And the focus is really to just see if there's not going to be duplication of effort and and frustration with the idea that the IPR system is going to promote efficiency. The one factor that has been particularly controversial, I think, is the extent that this applies not just to district court cases, but can also apply to an ITC proceeding. And this was born out of the original Fintiv order, which mentioned, I think, more really could be regarded as dictum, that parallel proceeding would extend to an ITC proceeding. There's been several follow-up cases where the board has followed that and denied institution because of a parallel ITC proceeding, which almost always is going to have a trial date that is going to be well before a final written decision. I noted with a citation on this slide, that's not a hard and fast rule, and it does illustrate that that it's a multi-factor test. In this one Phillips Morris matter, there was a prior petition was denied in view of the ITC proceeding, and then another petition filed on different claims that were only at issue relative to domestic industry. And in that case, the board said, that it really didn't matter that the ITC proceeding had advanced because the issues were different. So they applied the factor that looks at the overlap in issues. What we, in that earlier slide, one trend that is apparent is that while there's still a significant number of denials under Fintiv, it seems to have leveled off, and there was actually an overall decrease in number in 2021. And there's, commentators have offered different opinions for why that might be. It would seem that one, very significant development is there's an increased reliance on Solera wireless stipulations. Prior to Solera wireless, there was Sand Revolution stipulations that were a little more limited in scope, and it was pretty clear from the board's guidance on case-by-case decisions that the broader the stipulation made by a petitioner, the more likely that the board would be willing to institute. In Solera wireless, which was a precedential opinion from 2020, late in the year, the board made it clear that if the stipulation applied to any ground that was raised in the IPR or could have been reasonably raised, it would weigh heavily in favor of institution, and we've, I think, seen that pan out. I think there's other factors that might contribute to the leveling off, frankly, just as petitioners are more aware of the issues, and if they have a problem with Fintiv, might look at other avenues such as filing a reason. I'm going to briefly touch on another ground under 314, which is the general the board's practice under general plastic, which is dealing with multiple petitions. And here I think we've seen, again, kind of a leveling off on denials, and it's, I think, probably as practitioners become more familiar with the rules. But the trial practice guide made it very clear that if the board's really expecting people to file one petition per patent, if they file more than one petition, it's important to point out why that's necessary and, in fact, provide a ranking. There's instances where the board has looked carefully at that and scrutinized it, and even though they've indicated that it's a rare case, there have been cases where they've allowed multiple petitions to go forward, and it's generally just looking at length of the claims, complexity of the subject matter, things like that. I'll mention briefly, I won't go through the case in detail, but it's all these discretionary factors that the board has relied on recently really does present some challenges to a petitioner, and that they really have to think through their strategy, particularly relative to an ongoing litigation, and consider the impact of estoppel everybody's been aware of the risk of estoppel, but this has been re-emphasized in a very recent decision by the Federal Circuit in the Caltech case that makes it clear that it extends to any ground raised or reasonably could have been raised. So it's very important for a practitioner to look through and see how many claims are at issue and time the challenges appropriately relative to the litigation. I am going to briefly mention that, again, re-emphasize what I think a lot of us are aware of, that the board's application of Section 314 has been very controversial. There's a swath of the industry that really views it as inconsistent with the goals of the AIA. And I've listed some of the challenges to the board's application of Section 314, but it's not exhaustive. The most recent that I saw in the news dealt with Apple and Mylan's petitions for cert that were just denied by the Supreme Court. But there's been many cases where people have really, companies have really tried to get appellate review, but the challenge there is that denials of institution are of course unreviewable for the most part by the Federal Circuit. So denials under Fintiv, where there's been appeals, the Federal Circuit has repeatedly found that it just doesn't have jurisdiction to address the issue. In view of that, there's been a lot of interest in addressing the issue, potentially through legislation. There's a pending act introduced in the Senate, Restoring the America Invents Act, which would just flat out abrogate Fintiv and general plastic. And I note the PTO certainly is aware of this issue. They solicited comments and provided a summary of what they heard from the interested stakeholders, but so far it doesn't seem like that they've decided whether to change their approach and move to address these issues through formal rulemaking. I'm going to touch on briefly the other area where we see denials. This has been probably less controversial, and again, I think you could probably attribute it to practitioners just becoming more aware of the standards that the Patent Office has been applying, that the panel seem to apply in addressing denials under 325B. As we're generally aware, the board is currently applying a two-part framework as set forth in Advanced Bionics, which is essentially looking to see first, is the petition relying on art or raising issues that the examiner previously considered? And if so, this has been the area that's more controversial, I think. To what extent has the petitioner shown that the examiner made an error in the prior determination when the patent was examined? As I indicated, as reflected in the earlier slide, denials under this ground are still fairly significant. It's about a quarter of the denials, which I find interesting because, I mean, this is something that people can anticipate. If you identify prior art to challenge a patent, the first thing you can do is check to see if it was made of record. And I do attribute some of those denials to maybe a lack of appreciation of how this issue can play out, and a failure by the petitioner to really spend enough time addressing it initially. And I think the take home here is that it's important to really look through all examination of the patent, to look through all the art cited, not just art that you have as a potential challenge, but to see if it's also just cumulative, if it's being presented in the same way as art previously considered. This first prong of whether it was considered, I just note a couple of take homes from cases that have considered these issues. Often people will say, well, this art isn't really something that was considered because it was just cited in an IDS. But at least for purposes of this first prong, that's really enough. Usually the fight under this prong is whether the art is just cumulative of what had already been considered by the examiner. The bigger issue, though, is usually focused on, are the issues in the art really something that it presents a case where the examiner just flat out made a mistake. And the important thing to remember, it was made clear in advance by Onyx, and it's reiterated in many of the panel decisions that was issued last year, that it's not a matter of whether reasonable minds could disagree. It's really showing that if you're presenting essentially the same art or issues, showing that the examiner really flat out made a mistake. And I note in passing, often people argue, well, this is really a new issue because the examiner didn't have the benefit of expert testimony. And that doesn't seem to be working in terms of how the panels have treated this issue. They're really looking for a very focused analysis to explain how the examiner made a mistake. So I think the quick takeaway for this is be aware of the issue, make sure it's treated well enough if the petitioner, if you're representing the petitioner, request a reply to address issues if it's raised in rebuttal by the patent owner. And with that, I will let Mike address our final topic.
Oh, thanks, George. Interesting stuff. So yeah, we thought it'd be interesting or fun to end on a topic that's a little bit more forward-looking, a little more, quite frankly, speculative. But nonetheless, it could prove to be very important, and so we just thought we'd put it on people's radar screens and kind of start a thought process on it. And really, what it has to do with is whether, what the impacts would be, what would the outcome be, if Chevron deference goes away. What type of impacts might that have on PTAB proceedings? What might that mean? And we start just by noting that the whole framework, for the most part, for IPR proceedings and PGR proceedings as well, of course, were just very broadly granted to the director to prescribe regulations establishing and governing inter-parties reviews. So 35 U.S.C. 316A4. So just a very broad grant of authority to the director to establish these proceedings. And so, that kind of opens the door somewhat to, trying to challenge the rules and regulations and other things that the agency adopts. And for the most part, Chevron deference has kicked in and has, the courts have relied on it in a number of instances to find that what the PTAB is doing in various areas is okay, and it's going to withstand challenge. So one example of that came up in Quozo, where parties were challenging the PTAB's implementation of the claim construction standard, which at that time was the broadest reasonable interpretation. And, the broadest reasonable interpretation standard survived in Quozo, in part because of the Chevron deference that was given and to the agency's rulemaking authority. And just to clarify, and just to help folks, understand this a little bit better, who aren't necessarily experts in administrative law, just the general framework is that the courts are going to look to the statute first to see if it's clear. And if there's clear direction in the statute, then you don't have to worry about deference. You interpret the statute and you apply it. And that's something that happened, for example, in the Facebook v. Windy City decision that changed the rules a bit with regard to joinder. Folks may remember that decision from 2020, where the PTAB actually came to the Federal Circuit on appeal and indicated that Chevron deference should be given to some of the PTAB's rules on joinder. But in that case, the Federal Circuit said, no, the statute on joinder is clear enough that we're just going to decide the case based on the statute alone. We're not going to get into whether or not we have deference. But anyway, this is the framework that they use to assess agency regulations. Why are we talking about this? It's really because I guess two things. One, there was this Regulatory Accountability Act of 2017 that passed the House of Representatives back then, but did not pass the Senate. So it would have removed or gotten rid of Chevron deference given to agency rules and regulations. Did not pass, did not become law. But since then, there has been a lot of commentary from Supreme Court watchers who think that the current makeup of the Supreme Court is such that many people are predicting the end of Chevron deference. Of course, you can find different views on that, and we're not really taking a position on whether or not that is likely to happen or not. But we do note that there are a number of folks think that it's not a matter of if, it's just a matter of when the right case comes along and the Supreme Court does away with Chevron deference. And so we thought that merited some discussion of what could that mean for the PTAB if that were to happen. At the outset, there is kind of an extreme sort of view of that because so much of the AIA does not provide specific guidance, specific rules, does not provide a lot of specifics on how the PTAB's post-grant proceedings are supposed to play out, that, a lot of the PTAB's rules and regulations governing these proceedings could be subject to greater scrutiny, and that scrutiny would be that much more probing, if you will, if Chevron deference goes away. And so, what would the courts do? Presumably, they'd look to the text and nature and purpose of the AIA to try to interpret what rules should be impacted. But there's a lot of uncertainty there in terms of how far-ranging that could be. I also want to note that what the corollary to this is that where the statutes are clear, that's where you're not going to see the Chevron deference issue really play a role. And so one example of that is the statutory prohibition on getting appellate review of institution decisions. Since that's right in the statute, that's not going to be, at least I don't see a way for that to be subject to being impacted by whatever does or doesn't happen with Chevron deference. But what are some things that might be impacted? I thought it would just be helpful and fun to talk about a few of them. We know, as George just mentioned, there's a lot of interest on both sides of the Fintiv discretionary denial framework that's been implemented and is being used to deny some petitions. I'm not sure I see, or that George and I see a way that you can get at that even if Chevron deference goes away, because the courts are generally just deciding that they don't have jurisdiction to hear those disputes. So it's not clear to us that would really come into play, but I can imagine that the folks that are very much pushing to have that change would try to use any change in the deferential standard, to try to use that to advantage to get in front of a court somehow to get those applications of Fintiv reviewed. The claim construction standard could be potentially reviewed again. As I mentioned, in Clozo, Chevron deference was used to uphold the broadest reasonable interpretation standard then being used by the PTAB. That subsequently was changed by the PTAB. I can't say that I've heard a lot of commentary about the current standard, a lot of complaints about the current standard, but one could imagine that a petitioner that's not happy with the current standard might now try to have that revisited and do so, under the absence of Chevron deference, which is what the Supreme Court in Clozo relied on in the first instance. So, who knows? That's a possibility. The Arthrex review framework that's been put in place, which, we all know has at least been labeled interim sort of procedures, which implies that, there may be some different procedures coming in the future, and who knows what those will look like. But again, it's a topic that's generated a lot of interest and so one could imagine that those whatever that framework is at the time could be something that's subject to review. The motion to amend rules, there's relatively little statutory guidance on how the motion to amend process is supposed to be how it's supposed to be put in play by the PTAB. And so one could imagine challenges to those rules, the burdens of proof, et cetera, et cetera. And then another one that I found an example of here is just challenging whether or not you can use the same panel for institution and final written decisions. That was a case, an issue, I should say, that the Federal Circuit weighed in on in the Ethicon v. Covidian case. That was a decision back in 2016. But it's another example of where the Federal Circuit relied on Chevron deference to say, okay, we think that what the director has decided, how the director has decided to implement the proceedings and have the same panels, we think that's an example of something that should be given Chevron deference. And so they didn't disturb the way those rules have been implemented. But again, if Chevron deference goes away, could be subject to attack. So again, very forward-looking. Don't really know what's going to happen there, but it's something to keep an eye on. And if Chevron deference does change at the Supreme Court, then we can expect to hear a lot more about it in various challenges to what the PTAB's doing. So I just want to put that on the radar screen. Okay, I think that reaches the end of our webinar today. We hit the timing just about right on the nose. Didn't leave a lot of time for questions. I don't see a lot of questions in our Q&A box, so I think we'll just wrap it up here and let folks get on with the day. But we do want to thank you for attending, and I want to emphasize that both myself and George are here at Foley doing this work day in and day out, and we would always love to speak with any of you about thoughts you have, issues you have, of course help you with specific matters if you need that help. And we're here. We love doing this stuff and love talking about it. So feel free to reach out to any one of us, either one of us, if you have questions about this or anything else that comes up in this area. Okay, thanks everyone. We'll sign off.
Thank you all.
Thank you, George. Yeah. Bye-bye.
Bye.